This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a chiropractor was disciplined because he cheated on his billing, and why a chiropractor who lies to the licensing board will lose his license and right to practice law in the state of Illinois. An appeal came from an attempt by the state of Illinois to impose discipline upon Christopher D. Leone, doctor of chiropractic, due to certain improper activities performed as a licensed chiropractor in the state of Illinois. In Christopher D. Leone versus the Department of Financial and Professional Regulation, the Court of Appeals of Illinois, 4th District, on November 6, 2024, resolved multiple claims from the chiropractor that had been continuing for many years and many disciplinary actions. Leone has practiced as a chiropractor since 1999 and initially practiced in the state of Washington. The matter was resolved pursuant to an informal disposition via a stipulation of his first problem with the state in the state of Washington. Leone began practicing in Illinois in 2004, and in 2010, a consent order was issued pursuant to which Leone admitted to the allegations and was reprimanded with a $5,000 fine and a requirement that he undertake 20 hours of continuing education. 10 of those hours were to focus on Medicare billing and insurance coding, and another 10 on record keeping. In 2013, the United States alleged that Leone, quote, knowingly and fraudulently, quote, submitted Medicare claims of less than $1,000 for a one-on-one physical therapy service that were not provided. Following negotiation, the parties entered into a plea agreement pursuant to which Leone pleaded guilty to the one-count information and stipulated to a factual basis for his plea. Shortly after the Medicare fraud charge was filed against Leone, the state of Illinois filed a 5-count complaint alleging multiple violations of the Medical Practice Act of 1987. During the litigation, Leone applied to renew his chiropractic license, and one of the questions on the application asked whether he had been convicted of any criminal offense, state or federal, since July of 2011. Leone answered no, failing to document the Medicare fraud conviction, which he just signed. Attempting to explain his federal guilty plea, Leone said that he was unable to modify the language in the plea agreement as the time for negotiations had run out and the plea was a take-it-or-leave-it proposition. Leone read the plea agreement line by line, and although he claimed it contained false information, he signed it. The administrative law judge issued a report and recommendations finding that pursuant to the guilty plea in the federal case, Leone had admitted that his patients performed physical therapy on their own without supervision. Also, Leone admitted in his plea that entries in patient records indicating that they received hands-on or one-on-one physical therapy were false. Further, the guilty plea established that Leone knowingly submitted claims to Medicare for services that he did not provide. Leone had also billed private insurers numerous times under the same code with the same lies he made to Medicare. The conviction also established that he engaged in false billings and false entries in patient records. The ALJ recommended an indefinite suspension of Leone's license for a minimum of 2 years. Quite gentle. An expert testified that chiropractors who engaged in Medicare fraud violated several tenets of chiropractic ethics. There was a pattern of overcharging for services that were not provided, false notations in patient records to support the false charges, and the submission of false claims to insurance companies that went on for at least 5 years. Leone obtained fees by fraud, deceit, or misrepresentation, and those actions fell below the professional and ethical standards required of chiropractors in Illinois. Leone's conduct, along with his past disciplinary history, demonstrated to the Court of Appeal a pattern of behavior that was not acceptable. It was undisputed that Leone submitted charges under Billing Code 97110. Leone pled guilty to submitting a false demand for payment upon the United States. In his plea, Leone admitted to billing for services that were not actually provided to his patients as claimed, and the instruments containing the demands for payment of public money therefore were false when they were submitted, and were submitted to Medicare with the knowledge that he did not perform the services charged. The guilty plea supported the conclusion that Leone knowingly and intentionally submitted claims for reimbursement for services provided under Code 97110, where the services did not meet the requirements to be paid under that code. This pattern went on for approximately 5 years, resulting in 1,324 false claims in the amount of $93,000. The department established a violation of the Act where Leone failed to note the federal conviction on his renewal application. The Court of Appeal, after review of the initial circuit court order in the matter, revealed that it merely recommended that the department consider probation as a punishment. It did not make a ruling to that effect. There was no abuse of discretion as far as the Court of Appeal was concerned in the discipline imposed, and for the reasons stated, the court reversed the circuit court's judgment and affirmed the director's decision. Leone successfully committed fraud on the United States, the state of Illinois, and the insurance industry by falsely billing services he did not provide. He pleaded guilty to 1 count of federal health insurance fraud and then lied to the state of Illinois when he applied to renew his license by saying he hadn't ever been convicted. With lawyers and retained experts, he delayed the sanction for years. The Court of Appeals finally resolved the multiple disputes and applied an appropriate sanction and suspension of his license. He should consider himself lucky that he was not prosecuted criminally by the state and the U.S. government when the U.S. government simply accepted his plea and gave him probation, which he, of course, violated. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,900 blog postings. Please tell your friends and colleagues about this blog and let them also subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.